Hi, this is Melanie Murcott, Senior Lecturer from the University of Pretoria, where I teach administrative law and environmental law in the Department of Public Law.
And I'm Tim Hodgson. I am a legal advisor at the International Commission of Jurists, and I'm teaching admin law at the University of Pretoria at the moment.
And today we are here to talk to you about the Debeer judgment that was handed down on the 2nd of June in the North Gauteng High Court. And so we know that there's a lot of controversy and a lot of interest in this judgment. And as administrative law scholars and constitutional law scholars, we thought it might be useful to share some of our thoughts about it. Tim?
Yeah, so I think that the judgment has gotten a lot of attention, especially on social media. And there's a lot of things that I think are quite basic about what the judgment means, what the judge decided, why the judge decided what he did, and how that interacts with the administrative law that are quite important for us to discuss. So I think that we should maybe start there. I don't know what you think, Melanie.
Yeah, so Tim's very active on Twitter. So he has a better sense of what people are saying and the comments people are making. Maybe, I don't know, do you want to share a few of those?
Yeah, so I mean, some of the questions that are coming up are things like what now, right? So the judge has declared that these laws are irrational. So the regulations in their entirety, he's gone and declared the level 3 and level 4 regulations irrational. He hasn't told us his opinion on the other levels, including the original level 5. But what is the effect, before we start even discuss and analyze the judgment of that declaration? And what does the judge say about that?
So I think the first point to note is that the declaration declaring these regulations invalid has been suspended. So it is of no force or effect currently. And the government's been given 14 days to address the situation and report back to the court. So currently we still live under level 3 regulations as always. And then the second point is more of a procedural law point, which is that if the state were to appeal the judgment, which is quite likely, and there are a number of reasons why it might do so as a matter of law, then the effect of the judgment would be suspended by the launching of appeal proceedings to the Supreme Court of Appeal. So for present purposes, we should consider ourselves bound by the level 3 regulations unless and until we hear otherwise from government.
So even though the media and a lot of people are saying that this means that there is some change in our lives, really our lives are, you said the 2nd of June, which I think the technical term for it is yesterday. Our lives haven't changed between yesterday and today at this point in time.
Not at all from a matter of law. The level 3 regulations very much still apply. But I do think, and we'll discuss the significance of this later on, I do think that one of the important things the judgment has done is call into question the legitimacy of the entire scheme of the level 3 and level 4 regulations. So by declaring the regulations to be irrational in their entirety, obviously the judgment will have a massive influence on public opinion towards those regulations and respect for them. Of course, there's some doubt about whether the public respected those regulations anyway, right? And whether the judgment was the tipping point. So if there was a massive shift in behavior from the 1st of June to the 2nd of June after the judgment, I'm not sure. And we'll probably never know.
And then the last thing I think worth pointing out is that the judge also specifically says that the only regulation he's not willing to talk about is regulations relating to tobacco. So even if the judgment isn't appealed and the time for the suspension passes, for smokers out there thinking that they're going to buy cigarettes, this judgment doesn't invalidate that part of the regulations, even though their intention is to invalidate the rest of the regulations.
Yeah.
Then before we start, I think that we wanted to discuss some information about who brought this case.
Yes. So before we spoke about the who, I was thinking we could speak about the what, but we can reverse that order. So we can first of all speak about the who, and it is actually a very interesting topic. So Tim's got some nice insights on this question of who brought the case.
Well, no, I mean, I just did some Googling. So Reno David Debeer, this man, I can't seem to see the organization Liberty Fighters Network having any other staff. I mean, it's indicated that this is a voluntary organization, but it appears to be mostly Reno David Debeer. And he was representing himself in court, which you'll say something else about, which you've got up on that graphic, but also his organization was represented by another lawyer in court. Now, the things that you'll pick up on a few Googles of this is that the Liberty Fighters Network, they have a website and they have a Twitter page. Well, Reno has a Twitter page, and then there's a Facebook page for this network. This organization seems to stand for a whole range of different things, which include realization of rights, prevention of evictions, and stopping harm to the public, in addition to seemingly being anti-lawyers, though briefing lawyers in court. But if you go on the Twitter page that is linked on Reno's or on Liberty Fighters Network's page, it takes you to, I think, the personal page of Reno Debeer. And that personal page, if you want to look for it, is, let me find it now, at Gadvlei, so Gadvly, and his name is Liberty Fighter #1. And basically, if you look there, most of the tweets are extremely pro-Trump, or Alex Jones, who is the person after whom fake news was basically named. So the type of content here, other than the stuff about the regulations themselves and the Disaster Management Act, has all of the flavors of very right-wing content. In addition, the lawyer who represented Liberty Fighters Network is quite interesting. So I think it's Zahir Omar. I think that's his name. We can check at the bottom. So some of you may remember him from Twitter and, the interwebs, because after the case that was brought in the North Gauteng High Court to challenge the prohibition of religious gatherings, he was the lawyer who appeared outside of the court offering to represent anyone who broke those regulations and went and did their prayers and congregated and encouraged people to go and congregate. And this is what he became famous for in COVID. And here it seems that he has now actually taken up that deal and represented someone in court challenging the regulations, even though it wasn't for only the challenge to the provisions on gatherings, although obviously that falls under this spectrum of issues.
No, I think that's a really good summary of who brought the challenge. So I didn't do as thorough a search as Tim, but I did go onto the Liberty Fighters Network page to understand who the applicants were. It also struck me that Liberty Fighters Network seems to be the alter ego of Debeer. And the thing that stood out for me is what's on the slide currently, the idea that lawyers must fall, and that's because of the Liberty Fighters Network's belief that the legal profession of South Africa is the main culprit for all inequalities through its self-entitlement over our legal system and monopolizing access to our courts. And then it says, weirdly, every person has got the right to be represented in court by a person of his choice. So I don't know if that's advocating for non-lawyers to represent people in court, or what his grief is with lawyers. I mean, I do think there are some valid criticisms to be leveled at lawyers for for how expensive they are and how that can make access to court very difficult. And I do think that there's a need for legal representation to be more freely available. But what I find confusing is this idea of you should be able to choose any person to represent you in court, even someone who knows nothing about the law. And then when I watched some videos of Mr. Debeer, I also was quite struck by how similar he is to, the guy that you mentioned, the fake news guy.
Alex Jones.
Yes, I really, the first thought that came into my head was that this is the South African Alex Jones, and that it's quite weird that he claims to be speaking out on behalf of equality and so on, and against evictions. That all seemed very strange and disconnected.
So we've got this guy who seems to have this politics, and he's bringing this case to court, and he's got a lawyer who is very angry at the regulations. And then the question is, what are they challenging? But I think that the reason why it's not just for scandal that we are mentioning this, it does impact, we must understand what the judge had in front of him when the case was brought. So what did Judge Davis have as an argument in front of him on behalf of Liberty Fighters Network?
So I think one of the things that comes through quite clearly in the judgment, and this isn't to excuse any poor reasoning or weak reasoning on the part of the judge, but it comes out from the way the judge discusses the arguments and the concessions made by the state and so on, that both the lawyers for the state and the lawyers for Liberty Fighters Network and possibly Debeer representing himself didn't frame their cases very well, didn't argue their cases particularly well. And to be fair, we haven't read the heads of argument of either party, but from a reading of the judgment, it would appear that the matter wasn't particularly well argued, either for Liberty Fighters Network and Debeer or for the state. And that it quite possibly influenced what we ultimately see in the judgment. So what was challenged was, first of all, the Liberty Fighters Network wanted to have the declaration of a state of disaster declared invalid on the grounds that it was irrational. And second of all, the Liberty Fighters Network and Debeer wanted the regulations promulgated pursuant to the Disaster Management Act in the state of disaster to be declared invalid as irrational. The challenge was leveled against the level 4 regulations because the level 3 regulations didn't exist at the time. And then, so those are the two things that were challenged. And if we had to ask how was the case framed, well, it's really very hard to work out how the case was framed. So what we've put out here is how you could frame it if you were doing it in a sort of sensible and clear way. And it would seem that the case was framed as just like, this is all irrational and we want you to make it go away. And that's a sort of very under-nuanced way of saying it, but the matter certainly wasn't argued in the clear way of identifying what kind of conduct was under scrutiny, identifying the proper legal basis for the review, for the judge to exercise his power of review, and then explaining what rights were violated, why the violation of rights is not a reasonable and justifiable limitation. And all of that framing, as much as it's lawyer speak, it helps courts to properly justify the outcomes that they get to. And I know Tim has some very strong views on that in this case in particular. So do you want to give a little overview? So having said now what the way in which the case was framed, which is just to say, this is all irrational, it's all unconstitutional, make it go away. I don't know if you would agree with that assessment or if you want to add to it.
So it reminds me of and a lot of people have heard this, but the famous Australian movie called The Castle. And there is a challenge to environmental regulations or some kind of an environmental action which would allow for an airport to result in the eviction of people from their home, which is right next to an airport.
Mm.
And they go to court and the lawyer has never done a constitutional case, and the lawyer goes up in front of the court and he says, well, the problem with this happening is the Constitution. And then the judge says, but what part of the Constitution? And then he just responds, no, just the vibe of the thing. You know, I think that like this is the same exact type of circumstance here. The lawyers are just saying that this is all rubbish for every reason. What is typical in administrative law is for the first question, as you've said, to be what is the source of the power and what type of action is being challenged. So if it's administrative action in terms of the Promotion of Access to Justice Act, the grounds will be for the challenge, lawfulness, reasonableness, procedural fairness. And in terms of that, there's also a rationality test. But if it's executive action, so if it's not the decision of an administrator, but it's a higher up decision of an executive authority in the level of formulation of policy or something of the like, then it will be challenged in terms of the principle of legality, and it will still have to be lawful and rational, but it won't have to be procedurally fair necessarily in most circumstances, and it won't have to be reasonable. Now that becomes important. Then there's also human rights challenges where you can just say that this conduct violates my rights, and then you have to prove that the conduct violates rights, and then the state can justify why the limitation of rights has happened, because not all violations of rights, for example, imprisoning a person if they've committed a crime, are considered to be unconstitutional. So the framing of the case excludes all of this. And you can correct me if I'm wrong, Melanie, but I don't see any reference to the Promotion of Access to Justice Act in the whole case. And I don't see any discussion about whether or not this is administrative or executive action. And then there is an application here, which we'll see in the judgment, of the rationality test, which is a challenge which could come under the Promotion of Access to Justice Act, or it could come under the principle of legality. And then that is mixed with an analysis, which is there a violation of the rights, and is that violation justifiable? And very little reasoning that goes into explaining it. So if you look from paragraph 7 of the judgment, there's a very detailed list of things which the judge gives as examples of aspects of the matter that are irrational. So maybe we should get to, unless you want to comment on what I've just said.
Just before we move on, Tim has a very, it's every time, in fact, that he describes PAJA, he describes it as the Promotion of Access to Justice Act, but it's actually the Promotion of Administrative Justice Act, but that's I think, just a quirk that Tim has.
Yeah, my employer will be very happy to know that I'm so keen on access to justice. I was told by someone who watched the previous video that we need to say what PAJA means, so I try to say it all out. But so if we can get to now that thank you for correcting that. If we get to the part where the judge, the crux of the decision is that the judge says at the end that the conduct is unlawful, or the regulations almost in their entirety are unlawful, and the major basis to me seems to be that they're irrational.
Yeah. So I would just add to that maybe for 1 second that although the court doesn't explain if the conduct is administrative action or executive action, the court assesses the conduct on the basis of the principle of legality. So we can assume, which we shouldn't have to do, that the conduct is reviewed as executive action, which is a view that I think the declaration of a state of disaster is definitely executive action. But I think that there's a question mark over whether the creation of the regulations is administrative action or not. And I think we both have a view that those regulations are like, the creation of those regulations is likely administrative action. And then there's the directives that the judge refers to, which are not the subject of review, but the judge does engage with them, that are made in terms of the various regulations, and the creation of the directives, we would say, is definitely administrative action. So the judge does seem to use the principle of legality as his pathway to review. and then he uses rationality as an aspect of that principle to scrutinize the conduct. In addition, he seems to test the constitutionality of the regulations, but as Tim points out, he doesn't do that in a very clear way or a very explicit way at all. Okay, so let's go on then to the rationality analysis that he does.
Can I add one thing there? On the issue of directions and regulations, if you're reading this judgment, the judge doesn't distinguish between them at any stage and refers to all of them as regulations. So what I would say is that it's worth understanding this, that the way that the government has approached this, the executive, is that there are core regulations passed by the Minister of Cooperative Governance and Traditional Affairs, Nkosazana Dlamini Zuma. Those include the level 5, level 4, and level 3 regulations. Then those regulations allow for directions to be passed by other ministers on specific things. So for example, the Minister of Transport has passed a lot of directions on different aspects of transport, air travel, train travel, all kinds of things like that. Those directions are not the responsibility of the Minister of Cooperative Governance. And the only party to this case is the Minister of Cooperative Governance. So it becomes quite important that one of the aspects that I think we both agree is criticizable about the judgment is that the judge here is referring to as regulations, both directions and regulations, and reviewing both, even though the parties to the case don't involve the ministers responsible for all of these different directions. So although they are supposed to consult cabinet ministers and the Minister of Cooperative Governance is supposed to be consulted in terms of directions, the actual decision maker is, for example, when you are regulating what clothing can be sold, the Minister of Trade and Industry, and for transport, the Minister of Transport.
So it's another example of very bad lawyering, that you would challenge a directive issued by one minister as if it is a regulation issued by another, and that the court would treat these things as completely the same. And it's also bad lawyering from the state side to say nothing about this conflation of directives and regulations, and nothing about the fact that the other ministers weren't cited in the case, which they obviously should be if their directives were going to be reviewed and set aside. So there's a number of problems there.
Okay, so I think that the rationality analysis. So maybe we should remind everyone first, like what the basic rationality test is. So the judge does get this right, I think.
Yes. So this is something that a few commentators have mentioned, is that the judge explains what rationality means quite nicely as an aspect of legality. And so, Tim, I think while I pull up the screen, you can just tell us what that test is all about.
So the fundamental question with whether a decision is rational, and this will become important, is about the connection between a legitimate purpose, which the government has, which is founded in a legal power. So a legitimate purpose, for example, would uncontestably be trying to prevent the transmission of COVID and protecting public health and safety. And the Disaster Management Act includes several legitimate purposes. And in the end, the means chosen to achieve that purpose, right? So the means will be what the regulation is, the specific thing. We are banning cigarettes, we are banning alcohol, we are implementing a curfew. So you need to show a rational connection between the purpose and those means, and then you pass the rationality test. And our courts have told us repeatedly that the question here is not about what the best thing could have been for the government to do. It's given what the government has chosen to do, did it have a legitimate purpose? Do the means that it's chosen to achieve this purpose connect to that? And it's called a minimum test, a minimum threshold test, a some rhyme or reason test. But every single time it's explained to us that what we're looking at is just this decision.
Yeah, so normally a rationality attack is on a very specific measure, like one particular regulation where the means that are used to achieve the purpose are not connected to each other. So the court correctly explains this and says that in order to be rational, a measure must be connected to its purpose. So a particular regulation must be able to achieve its purpose in a very sort of theoretical way. So the court then wants to go on and apply that test to particular regulations. And so there's a long section in the judgment about applying that test. But before we get to that, it might be worth saying something about the difference between the court's understanding of what it means for conduct to be rational and the state's understanding of what it means for conduct to be rational.
Okay, so are you referring to this colorful passage which everyone has picked up on about ends justifying means and means justifying ends?
Yes.
So what the state seems to say here, the lawyers for the state, is that really if the ends justify the means, right, then it's fine for them to have undertaken the action that they've taken, which basically means, well, you know, if we get a good result, which is combating COVID, doesn't really matter what we do, and that might be the rationality test. Whereas my understanding is that what the judge says and what the law points to is that we need the means to justify the ends. So the government must show the means selected justify the ends, which I've been referring to as the legitimate purpose.
Yes. So I think one of the things that's important is that, and one of the reasons why this judgment is important is because it does highlight that the state needs to understand what it means to justify its decisions. It can't say, well, there's some good outcome that's achieved, so everything I've done is okay. That's no way to justify decisions. And so this is something that is addressed in literature on limitations analyses and how courts, how the state should justify its decision making. So Curry and Duval say in their book on the Bill of Rights that if rights can be overridden simply on the basis that the general welfare will be served by a restriction, then there's little purpose in the constitutional entrenchment of rights. And I think that that's a valid thing to take into account. So the way the state tried to justify its behavior and the regulations in this matter was to say, well, the general welfare of the people is being served by these regulations. And so that's another example of just poor arguments. Instead of trying to say, well, maybe these measures are not rational, but these ones certainly are, or this is why all of them are rational and why all of them connect to achieving the purposes of the act, which would be making good arguments that would help us understand why we have to comply with these regulations. The state just says, well, welfare is served in a general way, whilst at the same time conceding that the regulations do infringe upon our rights and freedoms. So I think it's worth just acknowledging that aspect of the state's position was very indefensible, and you can see why the judge sort of reacted to it in the way that he did.
Yeah, and so the judge also lowered down says something which is going to be of good use to the state moving forward. So he says that his impression is that the starting point for the government has been not to ask how can they limit our constitutional rights as little as possible, but rather to ask, well, what can we do to fight COVID, and then what rights can we afford to give people in this fight to COVID, right? And then just going from a place where they're willing to accept that we are not going to have the least restrictions on our rights, but rather as many restrictions on our rights that is necessary for their idea of combating COVID. So the judge is suggesting that the human rights approach to the COVID-19 pandemic would be to ask, how can we respond by least restricting the rights of all people in our society? And that might be some good guidance. But be that as it may, I think that the specific content of the judgment also then becomes important.
Yes.
Because, of course, the judge is not just writing general advice for the government. The judge is evaluating the rationality of the regulations. So are we ready for
Yes,
paragraph 7, the big one?
we're ready. So take us through the rationality analysis that the court did.
So it's very hard. Like, I'm going to do exactly what the court does here because we can't read through each example. But the court lists a whole lot of examples and specifically says that these are examples of regulations which it concludes are irrational. But if I read one of them, it might give you a good idea of how it comes to this, and we can illustrate this. So the one that's become quite famous is the hairdresser one. I think it's a good one for a whole lot of reasons. So let me see if I can find the hairdresser one. The judge here basically says that if you imagine a poor hairdresser who is having to take care of her entire family on her hairdresser.
7.3.
Yeah. So he says to illustrate this irrationality further in the case of hairdressers. A single mother and sole provider for a family may have been prepared to comply with all the preventative measures proposed in a draft alert level 3 regulations, but now must watch her children go hungry while witnessing minicab taxis pass with passengers closer in proximity to each other than she would have been to other people in the hair salon. So then he concludes she is stripped of her rights to dignity, equality, to earn a living, and to provide for the best interests of her children. So the first thing to note there for me is that the rights analysis is a conclusion, it's not reasoned. And there are many, many, many pages of constitutional court and other judgments explaining why something might be a violation of a right or not. And that's a complicated process. But if you leave that aside, the judge's way of explaining irrationality here is to say it is irrational to prevent the hairdresser from operating while you continue to allow taxi cabs to operate.
Yeah.
So what I think we have here is you have one decision, which is a regulation preventing hairdressers from operating. And the rationality test normally means, is that regulation rationally connected to the legitimate purpose of stopping COVID? And the general rationality test in law will stop there. The judge now has compared and said it's irrational because you've allowed other things which are more of a threat to COVID-19.
So do you think that that example is perhaps not a good illustration of how to apply the rationality test, but does point to the arbitrary nature of some of the regulations?
So the question here is whether the judge's purpose is pointing out a lack of logic, right, or bad policy making or advice, or is to find an illegality. So here, I think it's a bad application of the rationality test because the judge has not reasoned sufficiently to legally find that banning of hairdressers applying, which, by the way, still operates in level 3, some of the only people who are not allowed to operate. Because and so it therefore can be overturned because there's not enough reasoning there, right? And so it might be that you could make a case for why hairdressers should be able to operate, but under the rationality test, that case should be made independently of everything else that's allowed to stand. The inconsistency is not the most important thing for the legal argument, although it might be appealing to the sentiment or the sensibility of you and me as members of society. Because
can a measure that's illogical be rational?
A measure that's illogical can probably be rational in terms of the rationality test in law. Okay. And law works very weirdly like this sometimes, and it's not necessarily very intuitive. But the reason for this is, and we've explained it before, is that the courts have said that they will review decisions that the government make, but they have to have standards of review which defer to the government. So the rationality test is deliberately a low standard, which says all you need to do is to show us some reason why you have acted and some reason why that is rational in terms of getting the purpose that you want. And otherwise, it might be that it's a bad law. It might be that there's better laws, but the solution is then in people getting the government to change those laws, not in the court overturning those laws.
So if in each of these regulations, the judge had explained why the relevant regulation couldn't achieve any of the purposes in the Disaster Management Act, then you would say that he had correctly applied the rationality test.
my understanding of the rationality test would be, so also, and we discussed this earlier, but maybe we can discuss it now. I don't think that I'm aware of any case in which a whole legislative instrument or a whole policy has ever been declared irrational like that. This is the first that I've ever seen like that. Because normally it's specific decisions of specific provisions. And the reason for that is that to determine that a whole 30-page, 40-page document is irrational, unless you can prove that someone has flipped a coin and decided the content of that entire document, what you would have to do is you would have to reason through every single provision and say, this provision is irrational because it doesn't meet a legitimate government purpose. And so in any circumstances, it would be hard to come to that conclusion. But if the judge had, and in many of the other cases that have appeared, in the Esau case, in the Western Cape High Court, in several of the matters brought by the Democratic Alliance challenging the lockdown regulations or different aspects of them, had said this specific regulation is irrational for this reason to do with that regulation because it doesn't meet the purpose, many of these arguments might have succeeded. So many of these arguments are plausible. However they were made in front of the judge, in many of the examples, the judge reasons in the way that I've described now, which is in comparing one measure to another measure. And that isn't an appropriate legal way to approach it.
So the judge should have asked the question, is there a legitimate purpose for restricting hairdressing, rather than saying, how can hairdressing be restricted when people can sit in taxis together? So that way of reasoning is just a poor way of applying a rationality test. Have I got you right there?
That's right. And some of the sensible things that the judge says is that in some of the regulations, the judge questions why there needs to be blanket bans, right? So you might be able to, and many people have raised this issue, with many of the regulations that we have, instead of blanket bans, we might have controlled measures like we're allowing in the economy and allowing in the workplace. So our controlled measures, and then the question is it possible, right? Can we have controlled measures in a religious environment? Can we have controlled measures for gathering and protest? One of the better points that the judge makes, although it's not based on a finding of irrationality, in my opinion, is that there's been no attempt to allow people to gather to protest. And gatherings for protest are not exceptions, although gatherings for funerals are exceptions. And gatherings for religious purposes are now exceptions in terms of level 3. So the judge does make that point and say that the restrictions on gatherings to that extent might be irrational because of the fact that the specific nature of a gathering as defined in the Regulations of Gatherings Act, where this definition comes from, is not actually being allowed to continue. It doesn't even appear to have been considered, and then therefore that might be arbitrary. But that decision would have to be made by itself, not in comparison to other issues.
Yeah. Okay. So if we then just go through overall what happened in the judgment, so we can acknowledge that the court tested the rationality of various regulations, but it did so in a very loose way, and as Tim has pointed out, misapplied the rationality test in a number of respects in dealing with various examples of regulations that the court felt were irrational. And of course, we've already mentioned that the court didn't make clear why it was using legality as opposed to pudger in assessing the rationality of these measures. Then, in addition to that, the court seemed to assess the constitutionality of the declaration and the regulations, in the sense that the court seemed to assess and make findings on whether or not the regulations and the declaration violated constitutional rights, like the right to equality or the right to dignity, or the right to freedom of movement or to protest, etc. So the court did that without really telling us anything about the content of the right that was supposedly violated, how the right was violated, and so how the regulations failed to measure up to the right. So it did so in a very kind of glib way, this right is violated, end of story, no justification. And I think what we're getting at here is that courts are not fulfilling their proper judicial role when they don't properly explain themselves and justify their decisions. So Tim and I have different views on why the court adopted this approach, but one possible reason why the court didn't justify its findings on rights violations is because the state had conceded that rights would be violated. And then the state made no attempt, based on the reading of the judgment anyway, to justify why these violations were reasonable and justifiable limitations in terms of Section 36, which was its duty to do, having conceded that it had violated rights. But Tim has a slightly different take on this issue.
Yeah, so I mean, I guess also like it depends on where the concession is happening to, right? So the first thing I would point out is that although it's something which the judge relies on, it doesn't really matter for the purposes of this case what the president has or hasn't said, right? So the president is allowed to say all kinds of nice things like, I'm sorry for violating your rights to us on national TV. But for the purposes of the legislative enactment, there's a lot more thought that's gone into it. And the minister is entitled to justify whether or not there are violations and whether they're justifiable or not. But assuming that they've conceded in court, right, that there are violations of rights.
Which is how it comes across in the judgment.
Yeah, so assuming they've conceded those violations, that question, and I think that the questions should be, for the purposes of law, separated. So it's true that many of the measures taken do violate or limit rights, and they might be justifiable or not justifiable. But that should probably, in my view, be separated from the rationality inquiry. Because the real question with the rationality inquiry, if you are testing the rationality of a decision, is not whether rights are being violated, it's whether there is some reason that the government is acting. And so if you separate those things, you could more neatly decide the case. And if you do want to declare some of the regulations unjustifiable as violations of rights, that would encourage the judge to go through more reasoning and more detail to explain why that is the case. But I also think that there are aspects here, before we get to the order or anything like that, which are worth trying to recognize in the way the judge comes to his decision. So the determination of irrationality, as we've said, should ideally be on a case-by-case basis. So one of the problems that I would raise with this is that the judge does say that certain of the regulations are rational. The level 4 regulations in particular, and he talks about things like preventing evictions, things related to schools, all sorts of things like this. He does then also say that there are many provisions that he hasn't mentioned in the case that have not been discussed, which he is sure are irrational. And then the declaration of invalidity applies to everything except for a few exceptions. So what's clearly happened here is that the judge has applied the rationality test here to declare the entire regulation, with some exceptions, invalid, but hasn't actually given us reasons for all of those things. He's assumed that some of them or many more of them will be irrational. What worries me more about that is that the examples that the judge uses when he says, I assume some of the other things would be irrational, are examples from directions. So the popular things that are in the media about not being able to buy a t-shirt unless it's to go under a jersey and things like that. But those are not part of the regulations that are being challenged here or being declared invalid.
Yeah. So I think that's a fair critique, is that you shouldn't find things unconstitutional that are not before you as a judge. And also that if you do find things unconstitutional, you shouldn't do that purely on a vague and general assessment of the overall rationality of regulations without interrogating each of the regulations. So I think putting the best possible spin on what the court did, what I've said is that at least the court went through whether or not the declaration of a state of disaster was rational or not, and found that it was a rational measure. The court asked whether or not the National Council of Provinces ought to have been consulted, in formulating the regulations and found that that wasn't necessary, which I think was correct. And then the court found that the regulations were irrational, as Tim has said, in their entirety, and also said that because they were irrational, they couldn't be a reasonable and justifiable limitation of the rights that the state had conceded were violated. And so, and as Tim says, one of the things that was relied upon in this argument is the president's concession that during level 4 rights were violated, which I think that, there's some debate about whether courts can take judicial notice of that kind of statement. But more importantly, if the concession was made in court, then it did fall upon the states to justify why the limitations of rights was reasonable and justifiable. It seems that the state didn't make any real attempt to do that. And so you can kind of understand how the court could get to the view that if the measures were irrational and the state has conceded that they are a violation of rights, well then, in order to be, then the court said there could never be a reasonable and justifiable limitation of rights, because in order to be reasonable, a measure must be rational. So a measure that isn't rational can't be reasonable. And so the court conflates the violation of rights argument with the rationality argument in a not entirely implausible way, but in a very unconventional way, certainly, and probably in an improper way, because it's important, as Tim has said, to separate out why a measure is irrational and why it should be struck down for being irrational, versus why a whole scheme of laws is violating rights and so on. And it's important to justify that in a much more step-by-step, clear manner that tells the public the state of affairs much better.
So then there's aspects of this which I think we both agree on. So the one is that the state's lawyering, so the lawyers for the state have not done a very good job here, because they shouldn't have conceded many of the things which they conceded if they did concede them. Mm-hmm. And they haven't presented, there are definitely better arguments for why many of these regulations are rational, whether or not that will be the ultimate conclusion, than were raised. The second thing is whether or not the judge has a plausible, though I think very innovative way of coming to the conclusion, if you accept the version that Melanie has now presented. The judge's order doesn't match the judgment at all. Mm. So the judge declares all the regulations invalid, even though the judge hasn't actually engaged with all the regulations and only exempts certain ones. And even the ones that he doesn't declare invalid, he hasn't explained why they're not invalid. He's just said that they're good ideas. So it's, all we know is that it's this judge's opinion that it's a good idea to prevent evictions during COVID-19. Now, I agree 100% that we should have a ban on all evictions during COVID-19 disaster, but there's been no explanation, and an explanation is quite easy to give because it's a public health danger to relocate people, and people are being told to stay at home, so they shouldn't be evicted from their homes. It's quite simple to give that, but the judge hasn't bothered to do that. The third aspect that I think we both agree on is that the declaration of the lockdown level 4 and level 3 regulations is invalid is very surprising, because the lockdown level 3 regulations were not in front of the judge. The lockdown level 3 regulations only existed after the case was argued in front of the judge. And the minister and no legal representative had any possibility of defending the rationality of those regulations, yet the judge has declared them irrational. So they're not properly in front of the judge. And a last aspect, which I think that we definitely both agree on, is that the judge presents no reason why, other than there's a pending case on tobacco, why he cannot decide on that regulation, even though he's decided on all of the other aspects of the regulation. So it doesn't seem to me to be proper to just leave that aside. And why do I say that? Because although the judge notes that there's a decision, a challenge on the tobacco regulation pending, there are also many, as we know, challenges to many of the other regulations that he has now declared invalid pending all over the country, including at courts higher, the Constitutional Court in several cases. So on that basis, the judge therefore shouldn't be discriminating between that one and the other regulations.
Yeah.
I don't know if there's anything you wanted to add to that, or if that's a correct summary of what we would agree on.
I mean, I think there's probably more things that we agree on about the judgment, but I think that's a good, that's sufficient for now. So what I put on the slide is that the order amounted to sweeping relief, setting aside the entire scheme of the regulations for level 4 and level 3. And that's with an exclamation point, because in particular, it's quite shocking that the judge would set aside regulations that weren't argued before him, that he couldn't have properly considered in the hearing. They only came out on the 1st of June, or possibly late on the 30th of May. I'm not sure, but the matter was argued a couple of weeks earlier. So it's really improper for judges to do that. And yeah. I say that with all due respect. Judges don't ordinarily review and set aside regulations that haven't been argued before them.
So the question that I have is, can you maybe speak a little bit to, assuming that we were only talking about the level 4 regulations, what reasons in terms of separation of powers and judicial deference would the judge have had to not have such sweeping decision about declaring all the regulations invalid?
So, I mean, I think when a judge declares an entire scheme of regulations to be invalid, especially without justifying properly why he's doing so, he's in a way stepping into the shoes of the other branches and taking on their legitimate role. And that's not a proper thing to do within the scheme of separation of powers. So it's appropriate for courts to assess the rationality and the lawfulness of executive conduct, and it's appropriate for courts to assess the lawfulness, fairness, and reasonableness of administrative conduct. But that's not really what the court did here. So, I mean, I think in very basic terms, the court possibly went too far in the relief it granted. I mean, I'm being quite polite here, by really stepping into the shoes of the executive in an impermissible manner.
And whereas, as we discussed previously, courts normally in these cases are very, very careful to say that they are not supposed to take the position of the executive because of the fact that they're not with the expertise. And one of the worrying things to me about the way that this happens is that there are numerous references to information in the public and in the media. There have quite famously been judgments of our high courts that have done similar things. For example, a judgment on evictions in the Johannesburg High Court a few years ago by a judge who was eventually promoted to the Supreme Court of Appeal, that cited an article from The Economist as a basis for deciding that the government could not be expected to indefinitely house people who are living unlawfully on land. This type of thing does happen from time to time, but it's concerning because of the fact that judges might have their own personal opinions on policy, like we all do, on what should happen, but those judges are not appointed to have superior or overrule the decisions of the executive on policy matters. Many of these that we're talking about here are clearly policy matters, and judges are supposed to be restraining themselves to be dealing with the legality of issues. So I think that we'll see in an appeal of this case, if it happens, and in other judgments, much more care taken to at least present the decision in a way that doesn't step into the executive's terrain.
Yes. So I think it's an important point about reasonableness review and rationality review, is that the court is not empowered to ask, is this the decision I would make? Or is this the best decision? The court is asked to make a finding on whether or not the decision falls within reason, if they're assessing the reasonableness of the measure. And if they're assessing the rationality, they simply asked, is there a rational connection between the decision and the purpose for which it was taken, and the information before the decision maker. But I also, so when the court goes beyond that and sort of says, well, this is clearly nonsense, or this is all, sheer irrationality and inflammatory language like that, the court isn't really doing its job the way it's supposed to do it. Also think it's worth saying something about when the courts are allowed to take judicial notice of things that are in the public domain. So judicial notice is a rule of evidence that a judicial officer can accept the truth of certain facts known to him or her, even though no evidence has been led to prove these facts in the hearing. But there are very narrow circumstances in which the court can do this. This is where facts are so well known so as not to be of reasonable dispute. So it's general knowledge requiring no external evidence. Nowadays, even this is controversial, but the earth is a sphere. Might be something the court could take judicial notice of on that category. And then secondly, the court can do this where facts are notorious among all reasonably well-informed people in the area in which the court sits, or are readily ascertainable by accurate sources such that it's not necessary to require evidence. Now, I don't think that you can assess rationality on opinions about, does the number of people in a taxi influence whether or not people will get COVID. That's not something that's notorious and all reasonably well-informed people know. It's not something that's readily ascertainable by accurate sources. If it is, the court didn't refer to such sources in its judgment. So just generally referring to random newspaper sources and public opinion isn't going to be enough for a court to permissibly take judicial notice of information. And so I think it's important for people to know that courts can take judicial notice, but under very particular circumstances, and those circumstances are not the ones the court used in this case.
And there's two things to add to that. The one is that that the information that we're getting is changing a lot on COVID. And so for all of us, it's very difficult to keep track of. And so the arguments about whether or not something is rational or irrational are going to change. And courts should definitely try and make sure that they definitely at least have the best expert evidence at a particular time before they make those decisions. The second thing is, and we started at this point, the court has got a government litigant that hasn't raised very many arguments, if any, in court, clearly. It's also got a litigant and an applicant, which is this small lobby group, very clearly, who and an individual representing himself in court, who I can't imagine made very involved, detailed legal arguments based on what we've seen on his website and what we've seen about the ideology and what has come behind this. Probably quite polemically, generally against the lockdown regulations. And all of these things, one would have thought would have cautioned the judge to try and be a little bit more careful with the tightness of the reasoning, the compactness of the order, and the appropriate level of deference to the government. In addition to these being urgent proceedings, meaning that there wasn't a long period of time for the judge to hear the case or to decide the matter. So it's not for us to speculate why the judge did what the judge did here, but there are a lot of signs here which for most judges would be alarm bells for a more cautious approach.
And deference really requires respecting the expertise of the executive branch. Of course, it's difficult to do that when the executive branch isn't bringing its expertise to the fore in the litigation, right? But we don't know the details of the arguments that were made on behalf of the state. The judge refers to them as platitudes in one point in the judgment. But yeah, I think the judge definitely didn't show an appropriate amount of deference in the rationality analysis that he did.
There was one issue, I think you had it up now on one of the slides,
Yeah.
Which we should deal with because there's people who've been given what we don't agree with as views. So there was, I think it was the ENS, there was some article by colleagues at ENS who suggested that the decision based on the level 4 regulations was moot. I think that we agree on this.
Yes. So we've previously discussed it, that challenges to the level 4 lockdown regulations are not, in our view, moot. And one of the main reasons for this is because we can always revert back to level 4 and then be regulated by those regulations again. So they remain something that's constitutionally relevant in our society right now, even though we do exist currently in level 3. So I think that's just a bit of a narrow understanding of what mootness is from a constitutional law perspective, to say they moot because they don't apply right at this moment. If they can apply again in the future, then their constitutionality and their rationality remains a live issue.
Yeah, so the level system wouldn't make sense if we couldn't move down and up the levels. And that's the purpose of what the government has set up. So I agree with you, I don't see that as an obstacle to the challenge. I mean, really the more pressing problem is that the level 3 regulations just weren't properly in front of the judge, and the judge didn't deal with the specifics of the challenges.
Yeah, I agree. Yeah, so any other questions or comments about the judgment before we say goodbye?
I think that overall, the most positive thing that's come out of the judgment is that we have a framework that people have started discussing the legality of the regulations in terms of. It's better because we are now discussing using legal standards, lawfulness and rationality, and then also human rights standards, our opposition or support for regulations. Whereas previously, public condemnation of the regulations or support for them has been polemical and political. So especially because the Democratic Alliance in particular has led the attacks on the regulations, it's best that we try and understand what the actual legal challenges are and the objective arguments being raised are. And that's the useful thing about the rationality standard, is that it's supposed to be an objective standard which doesn't get into what policies are preferred or not. So I think that that's a very positive and useful thing coming out of this judgment.
Yeah, I agree with that. So I think it speaks to the value of litigation in general. Of course, litigation shouldn't be seen as a cure-all to constitutional crises. We have to deal with problems in our government or in our country in a variety of ways, recognizing that courts are a space largely for elites. That's the reality, and that is a fair criticism of the litigant in this case, even though he made it into court. But one of the values of litigation is that it can bring issues into the public domain, and so it does take out some of the party politics when people start discussing these issues in a more theoretical way. Because, I mean, I think, Tim and I have both assessed these matters in a sort of, as much as you can, neutral way. I've tried to look at the judgment from what's the best possible spin you could put on it, and then what are the major holes and what are the major problems as well. So not to advance any agenda, but just from the point of view of what is the law, where does the law guide us? And I think that more discussions like this, more analysis like this would be fruitful in helping us chart the way forward in challenges about how lockdown is regulated.
Yeah, and I think it goes without saying with what you've said, Melanie, that we're trying not to express opinions on the specific regulations either. So it might be that that I agree with some of the challenges here or some of the outcomes of particular challenges, but don't agree with the way that the judges come to them. And I think it's very important for many of the things here that are happening in court challenges and in how the executive is reacting and what Parliament's role is in the situation are going to have long-term potential impacts on our democracy during and after COVID-19, which could go for a very long time. So as a person living in South Africa and looking around the world, I'm very worried about what South Africa will look like in a year. And a lot of that will not only be up to what decisions are made in the minute, but whether or not we manage to continue to be a functioning constitutional democracy throughout. And in that sense, how the judiciary exercises its power and what Parliament is doing and what the executive is or isn't doing become extremely important.
Yeah, we don't want branches of government that are at war with each other. That's not really a good model of separation of powers. And obviously it undermines the rule of law as well. So we have to be quite cautious and cognizant of that.
Yeah, if I could summarize it, what I could say, what I'm going to tweet tomorrow about a judgment is not what a judge should be saying in a judgment. And what I'm going to say when I call my friend about policy regulation is not what a judge should be able to say in a judgment about it.
Yeah.
And the two things are different because it's an exercise of state power. And I would say the same thing for the president or the minister of police, who is a very good example because he's spoken badly and out of turn and inappropriately for the minister of police several times, where his comments would have been more appropriate, over a braai or something like that.
Yeah. Yeah, and the same with the Minister of Cooperative Governance, right? I think she brought a lot of her decisions into question when she made light of them and spoke about them in a very casual way. So yeah, I think there is a particular way of dealing with things that helps to improve the legitimacy of state power. And we can be critical of judges, and we can be critical of elected officials, members of the executive, and and we can hope for a functioning constitutional democracy.
Well, that's a good place, I think, to end.
Yeah. All right. Thank you.